In the spring of 2015, the world was stunned when hundreds of Rohingya refugees and some Bangladeshi migrants were stranded at sea in horrific conditions on overpacked boats. Abandoned by human traffickers after a partial crackdown by the Thai government, the boats were at first denied entry by all countries in which they sought refuge. It was a small glimpse at the plight of what the United Nations has called one of the most persecuted minorities in the world, and a glaring reminder of just how unwanted the Rohingya are. Today, the flow of Rohingya trying to escape Myanmar by sea has slowed in the wake of the crackdown.
My name is Said. I'm the moderator for this discussion. So we are going to discuss about the treatment of asylum seekers and refugees with regard to the principle of non-refoulement in Southeast Asia countries. So first of all, in 1951 Refugees Convention, it defines the refugee as the person who is forced to flee from its country of origin because of the violation or persecution. And refugees have their own rights, such as the employment, the access to the courts of law, and primary education. And in the non-refoulement principle, refugees should not be returned to their country of origin, where they would face the threats. This is based on the Article 33 first of Refugee Convention. And for addition, Malaysia is not a party of the Refugee Convention. So without further ado, let's go to the panelists, the first panelist.
And hi, my name is Nabiha. So my part is the treatment of asylum seekers and refugees with the regard of principle of non-refoulement in Southeast Asian countries such as Thailand. Thailand is not a party of 1951 Convention refugees because its government was feared that the ratification will encourage the arrival of refugees, asylum seekers, and migrants. Thailand has long failed in the respect of legally binding principle of non-refoulement, which is explicitly prescribed by the Article 3 of the Convention against torture and other cruel, inhuman, or degrading treatment and punishment, and it was considered part of the customary international law. And under this principle, the states are prohibited from returning an individuals to a country where they may face torture or other serious human rights violation. However, the government of the Thailand has violated this non-refoulement principle, such as like Mr. Furkan Sokmek was being sent back by to his country, and it was exactly that the Thailand government has violated this principle. Thank you.
So, non-refoulement in Indonesia. Indonesia not signed the 1951 Convention and also the 1967 Protocol. So, after Jokowi won election in 2016, the government did not differentiate between refugees, stateless or asylum seeker. So which mean for them, anyone who crossed Indonesia border without a permit was illegal immigrant. So before this, Indonesia has applied non-refoulement policy and give protection to refugee and asylum seeker. But after the 2016, there are many incidents, such as the incident of pushing back boat people back to the sea in Aceh. So in these cases, Indonesia must also express their disapproval clearly to the principle of non-refoulement before it is established as an international customary law. If proven otherwise, Indonesia cannot escape the obligation to comply with the principle of non-refoulement as an internationally customary law.
Hello, so I'll be talking about the treatment of asylum seekers and refugees with regard to the principle of non-refoulement in Malaysia. Now, Malaysian government has always respected the principle of non-refoulement, but this admission has clear and ambiguous position that has clouded the issue of non-refoulement for so many years. This is due to the reason that Malaysia's position with regard to this rule was not direct and clear. Like, for example, Malaysia has generally observed the rule, but in 2011 and 2012. Despite of a protest, it had deported a total of 17 ethnic Uyghur asylum seekers registered with the UNHCR in Malaysia back to China. Moreover, in the 2015, the Malaysian Coast Guard has violated this rule by committing pushback of boats trying to enter the territory in search for a place of refuge during the influx of Rohingya asylum seekers. It took the government a long time to finally admit that such rule is in fact constitute customary international law that binds Malaysia even in absence of explicit treaty. However, Malaysia also faced one major obstacles in policy, such as the Immigration Act 1959 and 1963, which contains provisions contrary to the rule of non-refoulement. Section 6 of the said Act makes it an offense for all types of persons to illegally enter the country. This has put Malaysia's government in dilemma and has legal reform not aligned with the international standards of non-refoulement. That is all from me. Thank you.
Hello. So, last but not least, regarding this matter, I take Philippines of what I want to discuss about. As you may know, that Philippines is actually a member of 1951 Refugee Convention, and because of that, Philippines actually bounded to the non-refoulement principle. But as we search it deeper, Philippines also even violated the non-refoulement principle. The case of it can be clearly shown by the case of Zareh Bari, where the problem occurred when Zareh Bari from Iran, she entered a beauty pageant in Philippines, and after that she received threatening message from Iranian embassy, and then she went to the Iran embassy for embassy questioning. During that time, she was detained like a prisoner inhumanly because she even said that she was exposed to 24 hours of light and she's not even served of hot water, and the Iranian authorities even denied visitors for her. In other words, she was basically mentally and physically tortured by the Iranian embassy. So during that time, it's clearly shown that even though Zareh Bari was sent back to the Iranian embassy and she was tortured, but then Philippines still allow it to happen, and this clearly shown that Philippines did not follow and violated the non-refoulement principle, which actually the signatory of the 1951 Refugee Convention itself.
Most of Association of Southeast Asian Nations, ASEAN, member countries perceive themselves as a non-immigrant nations. It means that the most ASEAN countries are not the destination for the immigrants to settle. This approach also been used when they responded towards the massive influx of refugees in the Southeast Asian region. In absence of the ASEAN Regional Mechanism on Refugee Protection, which means covered all stages of the treatment towards the refugee, a few ASEAN member countries like Thailand, Malaysia and Indonesia have valuable efforts and experiences in terms of refugee handling and reception based on their national policy and domestic law. For instance, in Indo-Chinese refugees crisis in late 1980s and 1990s, and also Rohingya boat people crisis in 2015. However, the member of ASEAN countries still want to help this type of people and take the legal efforts to reconcile their sovereignty in protecting refugees who enter their territories through law and policy.
As a conclusion, the treatment of asylum seekers and refugees with regard to the non-refoulement principle in Southeast Asian countries remain debatable and controversial every year. This is maybe because most of ASEAN countries still have no clear stand and in dilemma on refugee and asylum seekers issue. Most ASEAN countries also claim that refugees are a long-term burden and may become threat to their national security. However, these arguments do not reflect the spirit of international human rights standards, as every country internationally need to be responsible on the non-refoulement principle to allow refugees that seek protection in their country and have to allow them in. Thank you.